Welcome back to the Texas Agriculture Law YouTube channel. I'm Tiffany Lashmet. Today, let's talk about two lawsuits currently going on in Texas related to analog or plant-based or cell-cultured meat here in the state. First off, let's start off with the lawsuit called Turtle Island Foods versus Shuford. This case was filed in federal court in the Western District of Texas. We recently had a ruling in this case, and we did a blog post with more detail. We'll link to that in the notes below. This lawsuit deals with Texas Senate Bill 664. This was a law passed back in 2023, and it required specific language to be included on any analog meat product. Big picture, an analog meat product just means a product that's derived from plants, insects, or fungus that's combined with other additives to approximate the flavor, texture, or appearance of products like eggs, fish, meat, or poultry, right? So plant-based meat products would fall under this analog definition. And what the law requires is if you're going to sell those types of products in Texas, there are certain labels that have to be included. So somewhere near the name of the product in a fairly large size, there has to be language that says these products are analog, meatless, plant-based, some language like that. And the rationale for this law by the state of Texas is they want to avoid any confusion for consumers who think they're buying actual meat products and they're being somehow misled by these analog products. So that law was passed in 2023, and Turtle Island Foods, which is the company that makes the product Tofurkey, filed a lawsuit. And they said that this law violates a number of constitutional claims, including the First Amendment. And so recently, at the end of January, the federal court, district court out in West Texas, issued a ruling on summary judgment in favor of the plaintiffs. In other words, they sided with the Tofurkey company, Turtle Island Foods, and said that this Texas law does violate the First Amendment. A couple of key holdings that the court made to reach that. The first holding that they made is the court said that the speech here that the plaintiffs are doing, right, they're labeling that doesn't comply with this statutory requirements, that labeling is not misleading. And they really relied on the fact that Texas couldn't point to any examples of folks who'd been misled by labeling that didn't comply with the statute. So that was the first thing. They also found that the statute itself did not directly advance a substantial government interest. Those are real fancy words that are used in First Amendment cases. But basically, it means we're only going to let the government curtail speech if there's a really important state interest, and this is a really critical way to help advance that interest. And here again, the court said there's no evidence of a compelling state interest because the state hasn't really shown that there was a problem. And so what the court held is that both facially and as applied, so just the statute on its face and as it was applied to the facts in this case, this statute is unconstitutional because it violates the First Amendment. Again, if you want more details, you can check out the blog post we'll link to below. Do note that the state of Texas has filed a notice of appeal that was filed at the end of February. So we'll see what happens with that appeal in this case. The second case I want to mention involves a different statute, but still kind of this quote unquote fake meat related. This lawsuit is called Wild Type versus Shuford. And you might wonder why Shuford is the defendant in both of these cases. She is named in her capacity as the commissioner of the Texas Department of State Health Services. So they're using her name as the commissioner. It's really a suit against essentially the state for these laws. This lawsuit challenges Senate Bill 261 that was passed last year in 2025. And what that law did is it banned the production or sale of cultivated meat in Texas from September of 2025 through September of 2027. Now, by definition, this statute, cultivated means lab-grown meat. So essentially, Texas has said we're going to ban the production or sale of lab-grown meat in Texas for 2 years. Do note, I think it's interesting, Texas is not the only state to have done this. In fact, based on my research, they're actually the seventh state that has issued this type of ban on lab-grown meat. Lawsuit was filed in federal court by two California-based companies. Again, we are in the Western District of Texas here. These two California-based food companies have filed a lawsuit claiming that this statute is also unconstitutional. In particular, they relied upon the Commerce Clause, and they said that this statute discriminates against out-of-state businesses in violation of the Commerce Clause of the Constitution. We're still early in this lawsuit, but the court did deny the state's motion to dismiss. So, lawsuit gets filed. The state files a motion to dismiss. That happens before most discovery is done. It basically just says if we look just at the complaint that the plaintiffs filed, they haven't stated a claim. In other words, they haven't set forth facts that could show we violated the law. That motion was denied. The court said, no, we've got enough here to go forward to discovery. And so this case will proceed to the discovery process. So lots of moving pieces. It's an interesting time to be looking at this food law issue of analog and cell cultured meat here in Texas. Stay tuned for more on these cases.